looking at the fact that the close to 250 million, if not more, worth of the Gupta family assets have been unfrozen. And this is another case that has went south for the NPA in terms of the frozen assets for the Guptas and those linked to them.
I will respect the judgment of the court. Ordinarily, we are disappointed. We never thought it would actually go to this. But you must recall that we've got a preservation order in respect of the same asset worth about 140 million. We are soon going to be filing forfeiture papers. And that one is brilliant in the sense that they will have to come to the fore with and argue in respect of the merits, not on any technicality. I must hasten to articulate the fact that commingling is very technical. It is not yet a jurisprudence that is fully developed in South Africa. Commingling means when assets that are allegedly affected by issues relating to criminality are mixed with legitimate assets. That is where the court's focus today was. In fact, the judge, you were inside, he articulated it clearly that they're not disputing the fact that the contract that was entered into between Estina and the department is unlawful. Nobody is contesting that. So this does not affect the criminal case. We're going ahead. They will appear in August. He was not called upon to adjudicate on the strength of the criminal case. He did not get a copy of the docket. There were no witnesses called. There was no documentary evidence that was presented before the court that talks to issues of criminality.
Now, are you saying, based on that indeed the NPA is still very much strong, that come August, when you go through the criminal case, you are indeed going to make sure that you present the relevant evidence that is going to strengthen your case? Because right now, by the look of things seem like they're not going well for the NPA in terms of this case. The judge said there was not enough evidence to prove or to grant these assets to continue being frozen. What does that mean for the NPA and their style of investigation and taking matters to court without proper evidence or enough evidence?
That is a fallacy that we're perpetuating. I've just articulated our position that when we enroll a matter, there are reasonable prospects of success. And I've articulated the fact that this is not an articulation of the criminal matter. This is not a conviction. This is an acquittal. It is purely a judgment based on the application in terms of Chapter 5 of POCA, which was a restraint application saying that on conviction, the properties must be forfeited to the state. I've alluded to the fact that we've got a preservation that still stands, 104 assets worth of 140 million. We're actually filing soon a forfeiture order. That is where we'll invite them to adduce evidence that shows that that contract was entered into lawfully.